Good evening and welcome to the October 23rd, 2025 meeting of the Yorktown Zoning Board of Appeals. My name is John Meisterich. I chair the board. With me tonight are Bill Gregory, Bob Fahey, our attorney George Burns, and our assistant Nazreen Corey. As you can see, there's only three of us up here tonight, so that is a quorum, but any voting that we need to do would have to be carried unanimously. Okay, so for the order of this meeting, the first thing we will be doing is approving the minutes of the September 11th meeting. I'll make a motion to approve the minutes from September 11th.
Second.
All in favor?
Aye.
Aye. Okay. So if you are here, the first thing we're going to do really is set up next meeting. So if you're here under new business, we'll be likely setting it up for a public hearing on December 11th here in the boardroom. I may request a site visit. That would be done on December 6th. It's a Saturday morning. We generally start around 9:30 in the south end of town and work our way north, and we're done by 11 usually, 12 maybe. If you are setting up a public hearing for December 11th, you'll need to send out mailings to your neighbors. You send those out with a certificate of mailing from the post office, which is a cheaper option than certified mail. So remember, certificate of mailing, and those have to be postmarked between November 17th and November 26th. If they don't have those postmarks, we cannot open your hearing. In addition to the mailings, you will have to put a sign on your property, which we may have in the back, or Nazreen has them downstairs. You can come by and get them at any time. A picture of your sign and a copy of the notice that you're sending in to your neighbors. Okay. So, turning to our agenda, new business. Bisagna. It is 586 Madison Court. This is a application to renew an accessory apartment special use permit. So we will handle this administratively. I'll refer to the building department and set it down for a public hearing on December 11th.
Second.
All in favor?
Aye.
Aye. Pulver Miller. Same thing. So it's an application 2624 Windmill Drive to approve renew a special use permit for an accessory apartment. So I'll make a motion to handle this administratively, refer to the building department, and set it down for a public hearing on December 11th.
Second.
All in favor?
Aye.
Parpino? Is anyone here? Okay, this is a application for a special use permit for a renewal of an accessory apartment under new ownership that requires a special permit. So we noticed some discrepancies on this one, namely the size of the apartment is bigger than the code allows. So I will make a motion to do a site visit on this one. We will refer to the building department to get, hopefully, the original accessory apartment special permit to see if that was granted at that size and configuration, and set it. So a site visit on December 6th, refer to building as I just stated, and set it for a public hearing on December 11th. Do I have a second?
Second.
All in favor?
Aye.
Okay. Gazzola. Okay, 1281 McKeel Street. This is also a renewal for a special permit. It's for a chicken coop, not an apartment.
It's for the birds.
I think we need a site visit on. Yeah, so we'll set this one. I'll make a motion to set this down for a site visit, refer to the building department, and a public hearing on December 11th. Do I have a second?
Second.
All in favor?
Aye.
Aye. Okay. McCoy. This is 2192 Pondfield Court. This is an application to construct a shed with a side yard setback of 9 feet where 10 feet is required, and a rear yard setback of 8.5 feet where 10 feet is required. So I will make a motion to set this down for a site visit on December 6th. referred to building, and a public hearing on December 11th. Do I have a second?
Second.
All in favor?
Aye.
Pajari Alley, I'm going to ask you to just come up. We'll just do everything at once to the extent that we can. Swain. This is 3481 Alta Drive. This is an application to construct an addition that requires a combined yard setback of 12.25 feet, where 40 feet is required, and a previous variance for a side yard setback of 8.75 feet, where 15 feet is required, has been granted. So I will set this down for a site visit on December 6th, refer to the building department, and a public hearing on December 11th. Do I have a second?
Second.
All in favor?
Aye.
Bulfamonte. This is 3298 Poplar Street. This is an application to legalize a previously built deck that requires a side yard setback of 8.2 feet, where 10 feet is required. So I will make a motion to set this down for a site visit on December 6th, refer it to the building department, and a public hearing on December 11th. Do I have a second?
Second.
All in favor?
Aye.
Okay. Okay, so now we are at the adjourned agenda, and Pojari Alley, you're up first on our adjourned agenda. So,
Hi,
How
how
you
are you
doing?
guys
Hi,
doing
how
this
are you?
evening?
Hi, how
nice
are
to
you?
see you. Can you just state your name for the record?
Vincent Poggioriali.
And Christina Podriali.
Okay. So there's one application that's been open for quite a while now for a special use permit for a new daycare center. And in that process, going back and forth with the planning board, I see a second item on our agenda tonight, which is an application for variances for the build-out for a lot size of 33,401, where 80,000 square feet is required, a side yard setback of 8.4 feet, where 30 feet is required, and combined yard side setback of 48.4, where 80 feet is required. So I would assume that you would ask me to amend your original application to include the variances so that we could discuss them all tonight
Yeah.
instead of a separate
Yes.
application.
Yes.
That would be good.
You have all that information too?
Yes.
Yes.
So before I make a motion on that, I just want to ask if there's anyone in the audience that is here to speak about this application tonight? Okay. So the first thing I'll do is make a motion to amend your application for the special use permit to include a request for variances as follows: a lot size of 33,401, where 80,000 is required, a side yard of 8.4 feet, where 30 feet is required, and a combined side yard of 48.4 feet, where 80 is required. Do I have a second on that?
Second.
All in favor?
Aye.
Okay. So now everything's together. So do we have any comments or, for the audience or the members watching of the public, you came to us many months ago. We referred to the planning board because they're in a better position to finalize the details of a site plan, a traffic plan, tree plan, and all these things. So you went through that process with the planning board and eventually in September got a decree from the planning board or an approval
Yes.
for the entire site plan as we had requested.
Yes.
Yes.
So coming back to us is, unfortunately, the way the whole codes are written, they do the site plan approval and then we do the special use permit approval. So you had to then come back to us. In September, we weren't familiar enough with it because it was so new and hot off the presses that we didn't have time. I've reviewed everything, the thorough job that the planning board did, the referrals to the multiple agencies that they did, the changes that were requested that were implemented, the traffic studies. So everything seems to be in order from my point of view. So do we have any comments or questions from the
No.
board? So I will make a motion now. It's going to be a long one, bear with me, please, but I'll make a motion to grant a special use permit to operate the daycare center at 2829 Crampon Road for a period of 3 years, with the stipulation that the build-out be done in conformity to the site plan, stormwater plan, etc., as approved by the planning board on September 8th, 2025. In addition, motion includes to grant the variances for a lot size of 33,401 where 80,000 feet is required, a side yard of 8.4 feet where 30 feet is required, a combined side yard of 48.4 feet where 80 is required, with the stipulation that the variance approval pertains only to the requested variances and not the remainder of the property line. Do I have a second?
Second.
All in favor?
Aye.
Aye. You're done.
Thank you.
Thank you so
Thank you.
much. Thank you
Good
very
luck.
much.
Thank you. Okay. Have a good evening, guys.
Thank you
Thanks
so much.
again.
Be
Thank you.
well.
Good luck. Thank you.
Okay. Bartolini, 2145 Hunter Brook Road.
Evening, gentlemen.
Hi. This was an application for an appeal to the zoning board for a stop work order and a notice of violation issued by the building department. So can you state your name for the record, please?
So my name is John Bartolini.
Okay.
Did you receive my, yeah, they did. Did you review that? Yeah.
Yeah, so we received we had a meeting last month and we sent an email to you basically saying like what the instructions are for opening the hearing with the notification of the neighbors and, you know, asking whether you were going to do that because we adjourned the hearing last month. So we're really here tonight to talk about what your next steps are. We can't open a hearing here tonight because you didn't do the notifications. So there's really no like substantive content that we're going to be discussing. Basically, you can keep the hearing. What we would entertain a adjournment for next month if you're planning to do the notifications to the neighbors, the process required to get your hearing open.
Was that email that I sent you today delivered to them? Did you review that email I sent to you today? Because that is why I'm here tonight. That's the only reason. So you say that that I didn't do what I was supposed to do, but the town code is very clear. All such appeals and applications shall be in writing on forms prescribed by the board. This board has never followed the code. You guys need to prescribe a form for an appeal to an officer's decision. There is none on the website. It doesn't exist. I inquired probably 2 months ago. I suggested let's create one to comply with the law, and I'll excuse the town's deficiency, being reasonable.
So regarding the form, you filled out a form. I don't disagree with you that the form is confusing in the case where you want to file an appeal. However, you filed the form, it communicated what you were looking to do, and we set you down for the public hearing that you wanted. So therefore, the road may have been a little bit windy, but we got to the point where you were requesting we be, which is us granting you a hearing. So the question that I have for you is, do you want to have a hearing or not want to have a hearing?
So I am not confused. I read you the law very clearly, and I believe you folks are not following your law, and you're required to. It says shall. I was forced, with my son as a witness, to fill out a variance form. I disputed the legality of that. Over 2 emails. I disputed that with
Well,
the
if-
building
if you-
inspector.
I mean, if you want to, appeal our process or our forms, you don't appeal them to me. You can appeal them to whoever you want. We're here to either open the hearing that you personally requested, or dismiss it. So what is it that you want? Do you want a hearing, or do you not want a hearing?
I was forced to fill out a variance. That's not a hearing application. You
Well,
compel people to fill out forms that are not. You don't have the power to do that.
Yeah. I'm listening to what you say,
I understand.
and I'm not trying to whack a beehive, but when you talk about forms prescribed by the board, if the form was prescribed by the board, hey, fill out this form, whatever. There's no nomenclature that says it has to be addressing your specific issue. It's about a variance, so it's pretty generic as to how the form is issued, and you can comply. It doesn't have to be necessarily, like you say, verbatim for your argument. It's a form prescribed by the planning board to appear before us to present your situation. It's not an argument to say whether you're right or wrong. That's the form that was used so that you could get on a calendar and present your case.
The definition of prescribed is very clear
I
in
thought it
all
was
the
rather-
dictionaries.
What, even, you say the form was not, in your opinion, legal. However, the outcome of what you submitted was an appeal has been, an appeal hearing has been granted. So therefore, I don't know the materiality of the form, the outcome of what you were trying to do happened.
I can explain.
So therefore, you submitted this. Read the second part. You need to comply with the second paragraph to further your application. You're either going to do that, or we're going to dismiss it. That's it.
So the second, so I've made my prescribed argument multiple times in writing and to you here, and we are definitely having a disagreement, not a meeting of the minds. So that's a problem. You're not authorized by law right now to conduct this hearing because you didn't follow your own procedural process. And
I
now
set it
the second
down for
part
a
is this:
public hearing.
that
That's
the other day
that's the
I
legal process.
okay, so I'll just let me finish, and then we'll be
ahead.
done. I'm not picking on you guys at all. You've done nothing wrong to me, and this is just a procedural error. By the way, draw a form up, and I'll sign it. That's it. Because I want you guys to follow the law. I want you to follow our code. You're required to. And if you follow our code, then I will have faith in you that you will hear a hearing fairly. Now, there's one other issue. I sued the town of Yorktown last week in federal court. I also sued your law firm and your town attorney. This gentleman, I don't know his name. He's got nothing to do with this right now. But he does work for that law firm. Your town law firm is a defendant in a federal civil rights action right now, and they oversee this hearing, and there's definitely a conflict right now. I really can't get a fair hearing with them overseeing this.
See any hearing? I oversee the hearing.
They advise you, his duty
They
as town
advise
attorney.
me to the law. That's
They
it.
do advise you to the law, but there's a conflict because I've accused them in a civil rights
Well,
complaint.
wait, we're having a hearing. This is what you're doing now, and I told you we can't do it. There are procedures in place to recuse the attorneys or anybody else, but we do not have a hearing yet.
No, we don't have a
So
hearing
we need
because
to
you
get
didn't
to that
comply with the
point.
law.
We need to get to that point to have you request a recusal, but we're not at that point. If we want to open the hearing, you can certainly request a recusal. That's how it works. Very simple.
We don't have a hearing because you didn't follow the procedures.
That doesn't matter.
Well,
I did
you know,
follow
then,
the
then,
procedure.
then
I don't want to argue with you.
I don't want to argue with you. So,
So
you know,
our
I,
options here tonight, I will restate them. Very simple. We will dismiss the application.
You
or-
will?
Or
Mhm.
we will offer you an adjournment to next month with the stipulation that you're going to provide the required notifications, et cetera, and allow a site visit and all these things for us to be able to make our interpretation. But if you don't want to do that, we can just dismiss it, and that'll be the end of it for us.
so I'm going to reverse Uno and say if you don't prescribe a form, you have no legal authority to conduct a hearing. So you must follow our town code.
Okay.
This is how we got here in the first place. So,
So if you're basically telling me this is the same thing, that all this winds up as we're going to dismiss it off the agenda and that's it.
I'm telling you, you're breaking the law.
Well,
How am
that
I
remains to
breaking
be
the law?
seen. That remains to be seen. That's your opinion. You're entitled to it. That's your prerogative as to how you want to proceed. But at this time, we don't feel there's any kind of a mistake here. We're trying to say, and as I said before, interpretation of forms prescribed. In this instance, the form that we were looking to use was the form you're objecting to. There is no specific form for your particular situation. I guess we're going to have to invent one, but in order for us to proceed, we were following what is available to us. So if you don't want to go with that and
Well,
you
no.
disagree with us, then we're going to proceed the way
The law doesn't
just laid
say anything about the content of the form.
exactly.
It says a form must be provided. A form was provided, you filled it out, and the hearing, your right to a hearing was granted. So if you feel it's material that you did not like the form, that's your prerogative to do with what you wish.
And for the people of Yorktown, they need to understand that the form I was forced to fill out said request for a variance. That's not what I'm seeking. I'm seeking an appeal, and our law is very clear. And quite frankly, you're just giving me the runaround. And that's how we've gotten here in the first place, by town officials not following the clear code that we have.
Does it really make a
what-
difference, to tell you the truth? Does it make a difference? As long as you can get yourself out here and present your case, does it merely matter what form it is that you use to get here?
You and I are so close. We're like this close from having a meeting of the minds. Because I want this to work, you want this to work, and you have verbalized a way in which this could work. All I say is this: draw a form up that says appeal a decision of an officer or an official, just like most other towns have. And our law calls it. If you drew that up, I would sign that and we could have a hearing. But I need you to follow the law to trust you. If you politely tell me I'm confused, if you politely tell me I'm being difficult, look, I've already sued the town in federal court. I begged half a dozen times not to let this happen. I've already beaten you guys in county court, all right?
It says all such appeals and applications shall be in writing on forms prescribed by the board. How did we not prescribe a form for you to do what you were trying to do?
If a form says it's for A, and you must want B, you can't use Form A. You need a form that says Form B. It's that simple.
If the form opens the door for you to present your argument, to present your case, what difference does it make? Just use the form that's available.
Okay, so now we're going to go one step further. It's a constitutional issue, okay? And that constitutional issue is this. I could say, you know, you're right. I'm going to waive my right to procedural due process because I like you guys and I trust you guys. But when you ask me, when your code enforcement officer enforces laws I claim that do not apply to me because he was ordered by supervisor and town attorney, I don't have trust. And it's an abuse of code, okay? Misapplication. Then I come here and I'm like, well, this is pretty darn clear. This is maybe because I went to law school. I don't know. Maybe I understand this at a higher level. But I can't allow you.
The concept of material is something that you learned in law school. So how is this, it's not material if the outcome, it doesn't matter. I don't even want to keep arguing with you, but.
So we're not
you're-
arguing.
You're
We're
basically
actually-
saying you want it off the agenda because we didn't have the right form, and we'll take it under consideration as to whether to
All right.
change the form.
So
what
listen,
would
just-
you like
just-
me to say?
just-
I can't make a form tonight.
Actually, we could. It's actually that simple. We could draw up a form that says appeal a decision of an official.
We don't
And
have
John
that.
Bartolini can sign it.
don't
And then we could schedule a hearing.
Well,
And then we follow due process of law.
But the application submitted has a application for variance and it was crossed off. It says notice of appeal.
I love that you just presented that as evidence in this case. What that form says,
But
I'll repeat
but
it.
I guess what I'm saying is that the form was modified, and we have no problem with it being modified to say notice of appeal. That's the thing that was submitted.
It's a generic form.
That's not a generic form, that's a
It was,
variance form, gentlemen.
it was modified, it was
the only way we
modified
can
to
get you on the
say
calendar. There is no
notice of
form.
appeal.
Yeah.
And
So-
Being forced to use having emails back and forth, which
I think
is
that-
a fact, debating that we need a form, then me saying, create the form and I'll sign it.
we did create the form.
That's a variance
signed-
form.
you
So
signed-
listen, so here, this is very important. All such appeals shall be in writing on forms. Shall means it must be prescribed.
And it was.
That is a
It
okay.
was.
All right, so now you're wasting my time. All right, so what are you guys going to do? Do you want to draw up a simple form to code,
What if
and
I
I
write
sign
this
it,
is
and
the
then...
prescribed form right on top of it?
Okay, so we're
It's
still
already
arguing
filled out.
that? Because
No,
then-
we are, no,
No,
we're not.
no,
We're going
What
to be
if-
the end of the argument because basically
What if
the-
I write that on this form? Are we done? Can we open the can we open the hearing? You just said if I write up a form tonight.
only because we had to get grammatical in front of the town. I think it should be typed up, put on the website, and then I'll fill it out. Well, that's due process. I'm
It's-
doing
that-
the
that
town a
is-
favor
that is
by
not-
holding
It's
you
more
guys to the law.
theatrical than it
that's
is
not
practical.
that's not too far.
It
That is due process. That's creating a form. Your website actually says you can
Sir.
appeal
All right.
on the forms on the website.
Sir.
It doesn't
You're
exist.
trying to avoid a hearing that you personally.
I'm not trying to avoid anything. I'm right out front.
Sir, do you want to go, we will accept this form as the form. The zoning board has prescribed this form. We will accept this form.
Sir, you
And-
will follow the
and-
law,
and-
or I will make you follow the law.
And I guess my
your
question
prerogative.
is, do you want to continue with the hearing? That's the question. Do you want to continue with the hearing?
I'm going to continue and make you follow the law.
Do you want to continue with the hearing? Because if you want to continue with the hearing, basically what's going to happen is we're going to adjourn this matter for tonight. You're going to be required to notify the neighbors. You're going to be required to allow us to get on the property for a site visit. You're going to post a sign, and then we're going to have a public hearing next month. If that's your wish, we will do that. If you don't want to do that, then we'll do something else.
I only wish that you'd follow your law.
That's not my question,
Too bad.
okay?
Well, I make a motion that we dismiss this. That's, we're going around in a big circle here. This is not going to accomplish anything. We have other people that are patiently waiting for their agenda, and they've
Yeah, I mean,
complied. They've complied with the forms that have been given, so we can proceed with them. If you don't want to proceed, then that's the end of the evening. So, Phil, good luck.
Are we done?
Yeah,
Well, we haven't
as far as
voted.
I'm concerned, we are.
Okay, so I'll tell me when I can leave.
You absolutely can leave.
Yeah, okay.
I'll
thank
make
you.
the motion to dismiss this application. Do I have a
Second.
second? All in favor?
Aye.
Okay.
After that,
Anybody else want to protest
Everybody-
forms?
Yeah. You want to have a hearing or you don't want to have a hearing? I don't understand it, but whatever. Parisi, 3666 Old Yorktown Road, application for a building permit to construct a Tier 2 battery storage system that requires a use variance. Tier 2 battery storage systems are non-permitted per section 300-81.5 of the town zoning code. Okay. Can you state your name for the record?
Good evening. Thank you, Mr. Chairman and members of the board. Robert Gaudioso with the law firm of Snyder and Snyder on behalf of the applicant, Rick Energy. We submitted all the necessary forms. We have
Right.
no problem
I
with
hope
those.
so.
Yeah,
Under
300.
under protest.
No, we were good with
Okay,
the
all
forms. I think we even paid the fees. Thank you for your patience. Last month, we were here and we went into a great bit of detail on the materials that we submitted, but it being 9/11, we did not have our fire safety experts as they were respecting the 9/11 issues that day. But we did bring them tonight, and since the last meeting, we submitted a few items. I'd just like to run through those quickly.
Yeah.
We submitted a letter from Rick Tom Saunders, who's with us tonight. Basically just clarifying that the facility is not in the floodplain. I think we had discussed that, clarifying that the facility has already been elevated above the floodplain by 1.5 feet. We also confirmed with the property owner that the area where the facility is proposed does not flood, and she's also agreed that she will not use the property as a daycare facility if and when the facility is operational.
Was that ever a licensed facility, a daycare facility?
It was a comment in one of the letters.
It was a letter from the
And-
Westchester Planning Board
Yeah,
about
we-
it,
and
and
we just checked with her and-
we never even heard of that daycare center.
I can't speak to that, but I know that
It's listed on the internet, but it's not. Yeah, no, thanks. All right, no, it's just that as far as with daycare centers, there's protocols that we have to follow, and we've never heard of this, so that's why I'm asking.
all I can say is that the representation is it will not be used as a daycare center. We also submitted a letter from ESRG, and just some of the highlights of that letter, some of the things we talked about, very low incidence of BES fires, 5 fires in 2025 overall throughout the country as compared to over 210,000 vehicle fires, resulting in 350 deaths, just to put things into context. Many variables related to fires, but there was actual testing performed by Tesla and the smoke associated with that testing, where they purposefully destroyed the equipment to create a fire, and the smoke was light in comparison to other fires, and visibility through the smoke was retained.
Was
and we did
National Board of Fire Underwriters involved in that testing?
Yeah, so we submitted the entire report that you have for the record, and I have Chief Murray here tonight, and he'll talk about all the details. And the gases associated with that, fire were comparable to other structure fires. And most importantly, we had previously submitted the emergency response plan, which included the full ongoing training of both the Mohegan Lake and the Yorktown Heights Fire Department. So we submitted that based on some of the conversations I think we had last month.
Yes.
We did receive the letter from the county planning department, which we thought was very important. The county planning department reiterated the need for BESS. They called it, quote, crucial to the continuation of service, end quote. They noted that BESS safety technology has rapidly improved, leading to a significantly reduced number of fire events. They pointed out the fact that procedures in the event of an emergency have been established in order to manage safety issues. They also noted that the state has published the updates of the state fire code, and the county has a new notification law. And the fire code update is very important because when the town issued the prohibition on this type of facility, one of the things they relied on was the fact that the fire code had not been updated, and now it has been updated, and I think that's a really important point. The county also called BESS a land use that's normalized, just as gas stations are, pipelines, and electric transmission stations. The county also reiterated the fact that they're against any prohibition, and in fact, they recommended approval of the use variance. Now, they did have 3 comments from the county as far as the site plan, and I know we're not really at the site plan, and we discussed this last month, but we don't have a major opposition to any of the 3. The 3 were basically a water runoff containment system. We'll talk a little bit about that in a moment. Emergency response planning to incorporate traffic management protocols. Again, we have no objection to that. And finally, a proactive monitoring and shutdown system. And again, I don't think we have any objection to that. I think it's actually already there, but we can reiterate that as part of the planning board process. But what I promised you last month is we'd bring in a third-party fire expert. We have Mr. Dan Murray from ESRG with us tonight. I'd like just to introduce him, have him come up, run through some of the key points from the county comments, some of the prior comments, some of the materials we submitted, and then let you ask all the questions that you may have directly of him, because he's really the expert. So with that, I'd like to ask the chief to come up. Thank you.
Hey, good evening.
Hi. You state your name for the record, please?
Daniel Murray with Energy Safety Response Group. I also did not go to law school. So.
Smart man.
Just about ESRG. We bring a lot of expertise. We're all from the fire service on energy safety, energy storage safety, and we support various aspects of the product design, testing, permitting, training and emergency response. I am just recently retired 32-year member of the FDNY. My last 5 years, I was the chief in charge of hazmat operations for New York City, and all the battery related issues, lithium-ion batteries especially, fell under my jurisdiction, and we worked to develop code in New York City. As you know, one of the most densely populated places in the country, and we made sure that we had very stringent requirements when they installed these BESS systems in New York City. Like he was saying, that the new code was developed with input and by looking at the New York City code, and it is now the New York State code is the most stringent in the United States. And the system that they're talking about now is going to be under that code. Just about BESS systems, obviously, when there is an incident, they get a lot of media attention, and it's very well known. In 2025, so far, there have been 5 incidents in the United States. And then last year, the big one was out in Moss Landing, California. It got a lot of publicity. A very different situation than the type of energy storage system that they're proposing here. That was actually the biggest energy storage system in the United States. It was designed under old standards and codes, and they would actually never build anything like that now. So the system that we're looking at, not that one in particular, but similar, it's they're outdoors containerized systems, so they're all individually separated. And as he mentioned earlier, they fall under Underwriters Laboratory has the 9540A testing regimen that they have to go through extensive full destructive testing. That's something that ESRG actually does. So before these units are allowed to be installed, they have to meet the UL standard.
Is that done under the do you submit a report to underwriters, or do they actually send a representative to observe what it is you're doing?
We're authorized to do the testing by Underwriters Laboratory.
Okay.
And that's essentially, it's in the NFPA 855 code that has to be done. So this is a national standard that's followed in other countries as well. So just as far as the BESS safety, we've seen these systems expand throughout the globe and throughout the United States. New York is actually one of the big states where they're being installed just to support the grid. And even though the amount of systems is increasing tremendously, there's been a 97% decrease, which is in this letter that we submitted on grid scale BESS failures. And that's due to lessons learned from past failures and enhanced safety and stricter design codes and industry standards. So the unit that they're proposing to install is a Tesla Megapack 2XL. It's considered the most advanced unit currently in design. It has an integrated battery management system with built-in thermal monitoring to detect, mitigate overheating risks. The battery modules are designed with a liquid cooling technology to maintain optimal temperatures, prevent thermal runaway, and it also features isolation monitoring and fault detection systems to identify electrical anomalies, reducing the risk of short circuits and failures.
What's the coolant that they use?
It's I think it's liquid glycine cooling,
Okay.
and it's that's become the standard for liquid cooling in these systems.
As far as that coolant escaping into the environment, does the glycine have any environmental risk?
If the system's operating as designed, there's zero environmental risk.
You would think, but if something does go wrong and it were to escape into the environment, is there a particular harm that comes as a result of
That would be part of the fire, which goes into if there were a full system failure and fire, that would be one of the products that would be burning in addition to batteries, the plastics, the wiring, everything else. We get a lot of questions about, the smoke that comes off of a burning battery. So these batteries are actually designed if there was a large-scale thermal runaway and all the multiple layers of protection failed. They actually have Tesla has a sparker device, so it's constantly sparking within the unit. There's several of them in each unit. So if the flammable limits were ever reached, it would ignite them before you had an explosion. And then it has deflagration panels to direct any fire upwards and not out towards, if there were responders in the area. Okay. So I actually do the training of the fire departments, and that's kind of been my main.
Does the wiring, if the wiring that's involved with the system, is that a polyvinyl chloride, or what is the product
Yeah,
of combustion?
I'm assuming it's your typical whatever wiring they use. Yeah.
Okay. I mean, I remember years ago they had the fire in the telephone company, and they found out all about how great the plastics were, and
Yes.
the guys had nerve damage and everything else resulting from that. I mean,
I'm pretty sure the wiring used today doesn't have
probably
the same
superior to all of that.
chemicals and all that. Yeah. But when we do the testing of air, and this has been done even at the big fire at Moss Landing, the EPA they set up 9 air monitoring around the fire area. They monitored for several days. They didn't pick up any air hazards above OSHA standards. So even though there's a lot of smoke, most of it is your main off gassing and things that are burning is hydrogen, carbon dioxide, carbon monoxide, there's some propane, methane. Typically, when it burns, it dissipates into the atmosphere. And in that fire, there was another big one in San Francisco. We actually had one in Warwick. The air sampling and the water sampling around there didn't show anything that was raised concerns from EPA standards.
So within the package that was we have it in a Dropbox, which is what you're seeing up there, but I tried to review as much as I possibly could today. I did see a chart, and I'll never be able to even tell Nazreen where it was, like on which page. I probably should have noted that, but it does depict a failure rate, and I think you were like alluding to it a few minutes ago. And what I gathered from that chart was that as of current, it's 0.2%. So, and the chart goes like this. So when they were earlier adopters, the rates were higher. Is kind of what you've been.
It's almost like the same amount of fires, but exponential
but
increase in the build rate.
Installations. But so the question is, it's 0.2%, which is 2 out of 1,000, I suppose, or something like that. But does Tesla publish any kind of failure data? I mean, these are marketing materials, so they're not going to be, featuring that, when you're trying to convince people to do it. But is there anything that they could
We don't
provide?
get it from Tesla. We get it from the battery, the BESS systems in general. So it includes Tesla, CATL, all the other main manufacturers. And I'm trying to remember where we derived our information from. I mean, I think it mostly comes from like NFPA and EPA, and there's another. Trying to look at my notes here.
I think that was in the NFPA.
Is NFPA?
Right. Yeah, I see. It's not. It wasn't specific to Tesla, and I'm not sure how important that is. But a manufacturer would typically have like a huge amount of data on their own product, which would be pretty reliable for us to know. But
so there are failures that don't result in. If you have
yeah, I know.
each one has thousands of cells, so there can be a failure, but it doesn't propagate, and it's a non-event.
Yeah, the failures that I think a local town would care about are failures that cause dangers or problems. Not one of the cells went down and we're not storing quite as much energy as we could.
The concern is a full-scale fire of a unit.
And So the other thing is, if they're so new, the question is, as this technology ages in place, is it more prone to problems? In other words, you would think that if this is a 25-year life, the risks would grow as the stuff gets older, just through
So
various forms
what's
of
good about
deterioration.
most of these systems, and especially the Tesla Megapack, is the health of every cell is monitored through a battery management system. So they monitor the voltage, the heat, how many uses it gets, and the health of each individual cell. And it's remotely monitored by Tesla 24/7. So if they see any kind of anomaly or something's not right, they remotely will shut that down and send someone out to repair it or take a look at it. The
So
new-
it's a cell, I thought I read something that, like, within this structure that's maybe the size of a truck, right?
yeah,
Like,
yeah, like a container.
how many cells are in there that they're monitoring like that? Is it 6? Is it 600?
It's,
I don't need to know
it's
the
more
exact-
like, I think, I don't have the specs
like,
on
what's
that.
a cell?
It's
Is
several
it a big
thousand
thing?
cells.
Yeah, several thousand.
Yeah. So they've gone to, like, your cell phone is nickel manganese,
I don't know.
I don't usually do these testifying things, but the new technology, they use lithium, LFP technology, lithium iron phosphate. It has a more stable chemistry. It's less likely to go into thermal runaway, and it can charge and discharge more frequently for a longer period of time. And that's why, like, the problem with it, why they don't use it like in your cell phone, it doesn't have the same energy density as the NMC batteries that are like in your cell phone. So it's a little bit heavier. It takes up a little more space, but for a stationary system, that doesn't matter. So that's where they're all switching to that. So, I mean, we feel it's a safer technology. It's so far been proven that, we're having less and less fires as they do this.
As I was stating during the first hearing, which you weren't here for, we're here to talk about a use variance, which is not the same as approving the project. So I just want to point that out to you and everybody. If we were to grant a use variance, we would really just be sending you back to the planning board to continue the process that was started with them.
Yeah, we completely appreciate that. We wanted to make sure we gave you the information because I think there's been a lot of misinformation out there. So we wanted to correct the record on a lot of that. And more importantly, we wanted to provide that education and provide that expert, that third-party expert. But we completely agree with you. I mean, we think that the legal standard for the variance is generally, a legal interpretation by this board and a determination based on this particular application. But if the use variance is granted, we agree with you wholeheartedly. We have to go back to the planning board, and that's where I think some of the comments from the county become more relevant. I think conditions of approval regarding, the specifics of the
Yeah.
site plan, the specifics of the training, the specifics of the, the decommissioning plan, all the different plans that we've submitted. I think that's where the planning board would probably, dig into those documents, possibly hire their own expert to review them, and go through the state code on all of those requirements. So we completely appreciate that and agree with that, Mr. Chairman.
Okay, so do you have any questions or?
Have you basically completed what you want to present as your analysis for the argument that you should be considered under a lesser standard for the use variance?
Yeah, so in
Is there anything else that you want to submit at this point in time, or do you feel that you've given us all the information?
Yeah, so
that
just,
we need?
I think that's a great question. So just to summarize what we did submit, in my original filing, I did have all the legal case law about why the public utility standard is the applicable standard. We did submit the documentation showing that the Con Edison maps show that there's a need in the area. We submitted the what we call the Caesar report, which shows that Con Edison looked at this and agreed it could interconnect into their system. We showed the redacted interconnection agreement with Con Edison. I detailed the PSC orders and the New York State Climate Act and how the courts have interpreted those and relied on those, particularly in the Freepoint Solar case. I think that the county letter now has been submitted, and we've also submitted all the other documentation. I pointed out in my most recent cover letter that just within the last week and a half, the city of White Plains did apply the public utility standard in a very similar 5 megawatt type application in the city of White Plains. So I think that that's a relevant point that
Yeah, I was going to ask about that, and
Sure.
I guess I'm sorry I didn't see that in your memo. One of the questions I had is, do you have any other examples where this standard was applied to the battery storage as opposed to the solar, which is similar but not the same?
Yeah, so the White Plains is the most recent one because it's really, if you recall in Yorktown had a code provision in the late teens that was just a general public utility code provision. The building inspector determined that this type of use fit under that, and there was an application brought to this board, and then the town went into moratorium and enacted a code. And the town code actually regulated this as a special use permit. So it was and then a special use permit was granted over on Gomer Court for a very similar 5 megawatt facility using the same technology. So there wasn't the need for the use variance in the town of Yorktown. A very similar thing happened in Mount Pleasant in the same time frame, where Mount Pleasant had a code provision that was just, garden variety public utility use, special permit by public utility use. The building inspector agreed that 5 megawatt BESS was public utility use and granted the special, and the zoning board granted the special permit. Same thing happened in Ossining, and that's how this started to develop. Then there's been recently a number of moratoria, and there have been new codes. So, for example, Tarrytown enacted a new code and decided to regulate BESS Tier 2. And recently, I put in my cover letter, Tarrytown granted a special permit as a BESS under their BESS law. Yorktown is taking a somewhat unique position, is that it regulated it and then it decided to prohibit it. So that's a very unique situation. White Plains never enacted any regulation, so we were under the old code, which didn't regulate it. So that's why the use variance was granted there. So it's been a little bit of a hodgepodge because we're in a home rule state where every jurisdiction has their own code. But this is the only one I can think of where a municipality was regulating it pursuant to a code and then decided to specifically prohibit it. So that's why we're here for the use variance. But like I said, White Plains did just recently approve one applying the public utility standard within the last 2 weeks.
Is that something we could get minutes for?
We could send you the minutes. I can tell you that it was a different applicant, but I was the attorney. I can tell you that
Were you involved with the other?
I was.
The other ones that you had mentioned, like Ossining and Tarrytown. And,
So my firm was involved with Tarrytown. I was tangentially involved with Ossining. I was involved with the original Mount Pleasant approval, and I was involved in the Yorktown approval on Gomer Court. So I've been, involved with all of them one way or
Are there
another.
similarities to what you've presented here tonight?
Yeah. So the similarity, I think, that's a really good question. They're all the 5 megawatt size systems, which is
How about as far as location or
Yeah,
what the
so-
proposed
yeah.
areas
So
are?
so the 5 megawatts important because it's about the same size footprint. It's not what we've heard about in Carmel, where I believe it was 114 megawatts, 23 times larger, right? Apples and orange. Moss Landing, way even bigger than that. So same footprint. In Gomer Court, it's on a property that there's actually a house on the property, and there's houses across from Route 6. There's also on the property I believe it's an automotive repair shop. It's on Route 6, which is a major thoroughfare, and it's across the street from a gas station. And it's next to the lake, and it's right on the edge of the wetland buffer and the floodplain. So very similar circumstance as this. Mount Pleasant, the one in Hawthorne, is behind a church and a daycare center, right abutting the Sawmill River Parkway, major parkway. Tarrytown, excellent point that I want to make. Tarrytown, when it adopted its code to regulate BESS 5 megawatts like this, specifically has a preference and a requirement to be next to the highway. And that one is next to the highway, pursuant to that. So the idea of being near a highway is somehow a bad thing. Actually, Tarrytown looked at it as a requirement.
What was their reasoning for that?
I think the idea is that, you know, there really is no impact of being next to a highway. I mean, I know people have said there could be an impact, but as you know, you're bound by evidence in the record, not just unsupported statements. I think when Tarrytown looked at it, and they brought in their experts, you know, there was not this impact being next to the highway.
Was
and
it
being,
from a safety perspective that they recommended that?
I think the idea in Tarrytown of being near the highway is that it was an area, like if you're next to a highway, it's distant from other things, and there's already a transportation corridor. It's like, you know, in this area, we have Route 6, so the Gomer Court's on Route 6. So is the most recent solar facility that's behind Club Fit. So is the new tower that's on the corner of Route 6 and Hill Boulevard. So is, you know, the power lines that run through that area. So the idea is that you have infrastructure. This is a piece of infrastructure. It's a piece of electrical infrastructure. So being near the highways is near infrastructure. So I think that was the thinking.
Can I ask, I know that the one that you were talking about on Gomer Court was put in, what, 3 years ago or something like that?
I think it was approved, and I'm stretching, so I believe it was approved right during or right after COVID hit.
Okay.
And when it was approved under the older technology.
And
But they waited until the new technology came out, and they installed it within the last couple years.
I guess that my question is, the installation that we're talking about now has been, you've all indicated that it's going under quote-unquote the new code. Now, I know NFPA has come out with 855, a new one of those. And I know that the state code will probably be coming out in the beginning of this year.
So it's actually in effect now
It's
if
in
you
effect
choose to
now,
use
but
it.
we-
Yes.
but,
You must use it come January 1st, I believe.
Right.
But you may use it now.
Correct.
Even before the new code was adopted, I don't mean to cut you off, we had already agreed to meet whatever the new code was going to be.
I guess my question is there any information that you can supply to us that says how different the codes are that were employed for the Gomer Court
Yeah.
one as opposed to the one that we're talking about now?
So and I think you can speak to that. Yeah. So there's about a list of about 10 things
Yeah, I'm sure
that were
there
actually
are.
improvements.
Yeah, so the highlights, one of them is, it's mostly about the responsibilities and response. So now, if there ever were an incident, subject matter experts have to be there within 4 hours. They have to be responding within 15 minutes. The 4-hour rule is because some of these systems are way up in, you know, the Adirondacks and stuff. But like around here, it would be a very quick response by subject matter experts. That's people from ESRG probably who would be doing that. I think that's one of the best things about the new code. The signage has to be extended beyond the perimeter. And there's also a lockbox there with the emergency response guide that's developed and approved by the fire department with phone numbers they can get in touch with. It'll have maps of the site, of the enclosures, and of the equipment. The other thing is the emergency response plan. So that's something that you've seen the draft, I think, of that. I don't know if that's been okay. So yeah, it's a draft. It's not usually finalized until the system's built, and then it's reviewed by the fire department, and then we come in and we give the fire department extensive training, which includes a walkthrough of the site. It's a whole class on batteries. I've been doing that. Every time I do that class, the fire department's usually like, okay, we got this. This is something we can handle. And then the fire detection monitoring by a central station alarm. So that's basically like the alarms the fire department responds to every day for a commercial building or a school,
Correct.
or that's going to exist at the site as well. So if there were any kind of, a smoke issue or a gas issue, that would be transmitted to the fire department.
Does the your training for Yorktown and Mohegan, for them, do they become someone become an expert as to handle this type of thing, or is it somebody from the county that shows up? With you said 15 minutes.
Well, the
whatever?
expert's going to be somebody like a member of E ESRG who does this for a living.
Would the county have somebody like I know like the county has arson investigators that
They have a hazmat team,
Would
which
they-
is excellent.
Okay.
I've worked with those guys.
Somebody from that, would that have to be a request from the local department, or
The local
do
fire
they
chief-
automatically respond?
The local fire chief would
Would have to ask
probably
for-
request Westchester hazmat, I would think.
And the county adopted a code, I don't mean to interrupt, the county adopted a code, but now they have notification of all these facilities.
Okay, fair enough.
There hasn't been a fire in Westchester, so, right. But I would think if I was the fire chief, I would request hazmat, because why not?
I didn't know whether it was a requirement or not, or whether
But the requirement is one of us has to be there,
Right,
and
right.
we're not taking over the scene immediately. We're advising the incident commander, but we would like to, when we can release the fire department, it would then become our responsibility to, and then the whole process of cleaning it up and taking it apart and getting the system back running.
Mr. Gregory, I want to point out one other thing, that when these facilities started rolling out, and particularly when the first one came to the town, NYSERDA put out a model ordinance, and it required, a lot of what we're talking about is really at the building permit stage, and the NYSERDA model ordinance had a lot of building permit stuff, but we showed that to the town, and when the town adopted its code at that time, they incorporated everything that the NYSERDA code required. And when Gomer Court was approved, it was approved with all the things that the model ordinance required, which were all the things that we submitted here as well. So it was things that, I think Yorktown was really ahead of everybody else. So things like a commissioning plan, the fire department training, we met with the fire department before and during the process and afterwards. The decommissioning plan, the decommissioning bond, everything that we've done here was done in Gomer Court. So the code changes that are the most recent code changes come from the governor's working group, where they studied these prior incidences, and they came up with a list of things, like the chief just mentioned, that were now incorporated. But the nuts and bolts of NFPA, the New York State Building Code, the regulations of battery energy storage systems, those nuts and bolts haven't really changed. It's all these additional, safety factors, training factors, remote monitoring, which was all being done anyway, but now it's just been codified.
Yeah. Has New York City, has their code been changed, or is it stricter than the state?
There are some differences, but for the most part, it's the same.
Gotta step up. Thanks, Tommy.
It's pretty much the same. In fact, a lot of what the state picked up on was stuff that New York City already required. New York City always has the toughest fire codes in the
That's
country.
why I asked.
Yeah. And now, of course, New York City is going to also follow
Sure.
the New York State
Tweak
code.
it out, right. Very cool. All right.
So we'd be happy to provide the White Plains minutes.
Yeah, so that would probably be helpful.
Sure.
I don't know what your thoughts are as far as, there are some things that I would maybe have you answer to,
Sure.
whether you could do it tonight or not. That would be one of them. I think we spoke a lot about the risk side of the equation, which obviously is a very important part of this decision, because part of the standard is whether this variance is required to provide safe and adequate service. So that's a little bit of a different question than is it safe? is it required to provide safe and adequate service? I'm not sure just because it's safe that means it's required, right?
Sure.
So that's kind of one thought that's running around my head.
So could I respond to that while it's fresh? In June of 2024, NYSERDA put out the energy storage roadmap, and we submitted the press release from that. We also cited to actually the order that the PSC put out, and it was very clear in that order, specific to BESS, about the need for BESS, the need for BESS to stabilize the network, the grid, to be able to incorporate renewables, to meet the goals of the Climate Act, which the state legislature adopted, the electrification of the grid, stabilizing the grid, and that order is very specific about the need expressly for BESS, and we did submit that.
Okay.
What Freepoint, the Freepoint decision, which we cited too, and there were a couple different decisions. The first decision is that the zoning board in that case failed to apply the public utility standard, went up to the courts. Court said, no, the public utility standard applies. They remanded it back to the board. The board denied it, applying the public utility standard, and they were overturned again by the courts, because one of the things the court stressed is that it's not, whether a particular facility is needed, but whether there's a general need. And the courts were very, very clear about that. It's a general need for this type of use. And the standard, as far as safe and adequate, when you get to the safe part, is where you're looking at, some of the site plan issues. But that was very clear by the court. And then the other thing we cited too was what I alluded to earlier, was the fact that we submitted the Con Ed hosting map showing the need in the area. We submitted the Caesar, which confirmed the interconnection into the Con Ed electric grid is feasible at the proposed location. And we submitted the actual, the agreement showing that we have an agreement with Con Ed for them to accept this. So they wouldn't accept this unless they actually needed it, right? So we have that actual agreement. So we submitted all of those documents are part of the record. There's not much else that could be submitted. Those are the same exact arguments. Those are the same exact documents that White Plains relied on, by way of example. So I didn't mean to cut you off, but I just wanted to make sure.
No, that's good. It's hard to synthesize 300-something pages into,
I understand.
what we're trying to evaluate.
Just as a matter of course, has this property's insurance carrier been notified of the intent or the proposed plan? Have they had any feedback or commentary as to what's proposed for this property?
I can tell you under our agreement, we have very significant insurance requirements that we have to be able to insure the facility. So that's where it's all covered.
Who would do the insurance for this? Would they be under a reinsurance program, or?
I don't know. I don't know specifically who we would have,
Out
but
of curiosity, who would insure that type
it
of
would
thing?
it would be something that would be required once we construct it. But that is a requirement that we have the necessary insurance, and I don't think we'd be objecting to any providing proof of that at the building permit stage.
So, I don't know, this might be kind of what I'm looking for or not, but is there like a distance off some kind of main power line that these things need to be? Because another part of this is, and we did talk about this last time, but I can't remember all the details, but I think Bob brought it up earlier, and it is in this county memo. There's a daycare center supposedly on the site. Now, it could be an in-home daycare, right? Because that's kind of like an unregulated thing where there's like 14 or lower amount of kids. But it gets into, to me, we're in a residential zone with a house with a right, at least, to have in-home daycare. Right, and I don't know that we can take that right away.
We've offered to take that right away. So we will
I don't know
consent.
that that's can
we will consent to not have a daycare center on the property.
I can
put
see
that in
that,
writing.
but the owner of, so who owns the house?
We submitted the letter of authorization from
Right.
the property owner.
So the
and that's
property
who's listed
owner
on the
is the
application.
one. They always have a right to their property, right? So
Well, they're a
can we?
co-applicant.
I don't know, I'm just asking that as a question. If we put a condition, no daycare, is that denying someone a right that they would,
so-
would that stand up as something that
You
could
could
be
say no
denied?
daycare as long as that facility is there. Remove the facility, then you can have your daycare again.
Yeah, and
No,
we've put that in writing, the October 15th, 2025 letter that, and if you want to have that documented any further, we'd be
Yeah.
happy to do that. And the owner of the property did sign the application forms as part of the variance.
Yeah.
Right, but they could sell the property. This is 25 years, right?
So we could do a, you know, we could do a recorded document. You know, we can record the consent, we can record the condition and the consent to the condition. We'd accept the condition that we expressly consent to it and record the resolution.
Would that go along, say if they sell the property?
Yeah, it
would
would
that
be,
still
and we
in
could
perper-
put
in
right in the
perpetuity?
resolution, as long, this property is encumbered with
I mean,
this.
like the variance is forever, right? So it's like, you don't know what's.
So the
gonna-
variance for the facility would run with the land, subject to this site plan, I agree with that. But the conditions of approval are the conditions of approval.
So really it gets into, in terms of where we're gonna deliberate is, you know, I don't know who's required to present other options, you know, were other options ever looked at or other options feasible? You know, even if it's not a house with a daycare center, in terms of residential character, you know, that's another issue that comes into play in terms of alternative sites. You know, I'm very nervous about a residential zone. on
So it is a split zone. It's
Yeah.
partially a C2 zone, which is very important. It's next to a highway, which is, you know, I'd say a non-residential use. It's not in a highly dense area. It's in a no more dense area than I would say Gomer Court was, very similar circumstances. And I think the most important part is that I don't believe we have an obligation to present alternative locations because the code prohibits it everywhere.
Everywhere.
If the code had said you could only go in a C2 and we're in an R1, then I think we'd have probably an obligation to look at the C2 to an extent. And I think when you look at the Con Ed v. Hoffman case, I think that the issue of alternatives is very narrowly prescribed. And we have no alternatives here because no matter where we went, it would be a use variance. There's no criteria that says this property is better or worse than some other zone property, other than just, you know, the factual circumstances of this property, which, as I mentioned, are very similar to Gomer Court.
So before the change in the law, this was permitted in this,
It was a permitted
was
use.
permitted?
Well, I think it was special permit, yeah. So
by special
permitted,
permit.
yeah,
So
permitted
was
by
it
special
permitted
permit.
was it permitted in any residential zone?
It was permitted in a residential zone.
Yeah, I think that's what we had originally applied as.
Yeah.
But there was the moratorium that was in place at the time,
Right.
so.
I
So
want to
let me
adjourn.
ask for members
Yeah,
of the public.
please.
Are there any members of the public that have, so we're going to have some public commentary. So, yeah, when you get up, just state your name for the record, please.
How are you? My name is John Barry. I'm living 3590 Old Yorktown Road. I'm just a little bit above this. I can nearly see this from my house. I'm very disappointed I have to come up here because of this. You know, it really disappoints me because I'm actually going to represent a couple of neighbours that can't come here tonight. First of all, I want to say one thing. The signage that they have up for the application, you can't even see it. Nobody knew it was there. It's facing as the road goes down, as the street goes down. When you're driving past, you're like, "Dung." You don't even know it's there. None of my neighbours even knew this was going on. They had no clue because of that. There should be a sign facing every way. If you're driving down, you can see it. If you're driving up, you can see it. And we had no clue, only my wife said to me about what was going on. Anyway, my neighbours are not happy with it. We're a very close-knit community down in that little section. We all know each other, basically, you know. Nearly every one of us we moved to Yorktown. I brought my family up here in 95 because I came here because it's a lovely area. I love what's going on around the town. I'm very, very happy. To have this down below me is not good. No matter how good your technology is, it's never going to be good enough to protect everybody around it. There is always faults with technology, no matter how far it is in the future. Your little computer gives problems. There's, along the way. I'm not advanced in everything, but I do know batteries a little bit. I've seen battery fires years ago. A little maybe different aspect of what we're talking about now, but they're not pretty. The hazard material that's going to come from it, they say they can contain it. Can you contain everything? You can't. Down along there you have a lot of little woodland areas. You got a trail right alongside it. Beautiful stream. I've seen that stream flooding a bunch of years ago. You've probably seen it as well. We had a very bad storm come through. That water was very high. There was nothing passing there. A fire truck was not going to get through. So if they say they got their little problems, with, God forbid, hopefully it'll never happen. But if it did happen to happen on that big storm and they had that fire issue down there with the safety hazards, then fire trucks might not be able to come in there. It's a very low level down there. You know what I mean? It doesn't make me happy. Plus, that is a childcare centre down there. It is on the internet, like my wife was saying. It is there. You can actually look it up, We're not happy about it. Neither am I. I'm very close to it. You have even closer people residential to me than I am. They're at all not happy. I wish there was a few more, but they couldn't come. A lot of people I spoke with, and my wife spoke a lot, they had no clue that this was going on. Absolutely no clue whatsoever. There would have been a lot more representatives here tonight if we had known this was going on. It's sad that it has to go to this extreme on a lovely, simple community like Yorktown. I know you have advanced technology and all this and where we're going, but we're a very, very close-knit community here. We want to keep it the same for our kids, and we don't even want the slightest chance of any mishap. A slight chance of any mishap with these chemicals going into the air, with the way the prevailing winds can blow, it can blow right up to me. It can blow up to all the young kids. There's a young family just moved in alongside me there maybe 3 or 4 years ago. Beautiful family. I'd hate to see anything happen to them. I'm hoping that you take into consideration what I was saying for our sake as a community. That's really what I have to say. Please, if you can, for us.
Thank you.
Thank you so much.
Thank you.
Any other comments from the audience? Okay.
Should be adjourned. Adjourn.
Adjourn or-
Adjourn. What Tony is to analyze the legal
Yeah.
stuff that was submitted.
Any other comments?
No, the only thing I'd say is we did send out all the notices.
Right.
This has
No,
been
I
on the
know, I
agendas
know.
for
And
almost
I-
2 years now. This is-
We probably have a picture somewhere in the records of the sign and
did
all
submit-
this.
we did
and,
post the sign
I
properly,
wish
we
we
submitted
could
it.
do better,
Yeah.
generally with
But we
our
did send
sign.
out the certified mailings and multiple times. And
So, I assume that you don't have more information to present.
Well, you're gonna present some information.
Well,
for-
we'll submit the
yeah,
minutes.
And it really leaves it up to us to start really digesting all of this. I would say we would adjourn till next month and be more clear on our
Sure.
information. I don't want to let it drag on forever by any means, but it's a little too much for us to, given everything that we're
No, we
trying to
appreciate
drink
that.
from the fire hose, is like,
Sure. No, we
you know,
appreciate that.
get it to a decision point this quick.
And what's the meeting date next
It's
month?
December 10th.
December. I thought it was
December
December 11th. Okay, so no November meeting because of the holiday.
Yeah.
Correct.
So we put it early in December.
Would you be willing to close the public hearing subject to maybe a 10-day period that that the written communications
I
can
would
come in?
prefer that we adjourn it,
Okay.
quite frankly. So we're
Okay.
going to pick this up again.
So make a motion to adjourn this hearing until the December 11th meeting. Do I have a second?
Second.
All in favor?
Aye.
Thank you very much for your time this evening.
Thank
Thank
you.
you.
All right. Is it done?
You gotta
Are we done?
you gotta
Yeah.
reassemble it.
We got lots of stuff here.
Yeah, I know. Okay. Nunez?
Put this back together,
Yeah.
and then I will put it away.
I think I didn't take much out.
How are you?
Fine, sir.
we are good.
Okay, if you don't mind, so this is a application for a special use permit renewal of accessory apartment at 3240 Hollywood Street.
Yes, sir.
So name for the record, please?
Jose Nunez, sir.
Okay. So I'm just going to see if there's a memo from our building department.
There is.
So on October 20th, Steve Frayetta, assisting building inspector. This is an application for a new special permit? Is it a new apartment or a renewal?
Renewal, sir.
Yeah,
That's for renewal.
he said new, but
It's
it
a
must
new
be
renewal.
Renew.
Inspected the property
New renewal.
and found existing apartment to be legalized with no occupants residing at this time. The applicant has filed a building permit application and will require a certificate of occupancy. I have no objections to granting the special permit. It's a little unclear from his memo whether this is new or not, but
That plan actually is not the real one. And I provided 3 large copies, actually,
Okay.
to the engineer department, I think.
Yeah, he's probably got them in the file.
so how long is this, like, you've never had you've had a permit in the past or no permit in
No, I
the?
did have no permit, sir.
Okay.
And, I've been living there since I got divorced, since 2014, 2015.
Did you build the apartment originally? Did you
Yes,
make it?
I've been
make
actually
it an
working
accessory?
it. I've been working on it.
So it's not really a renewal, this is like an initial one now. Do you know how big the apartment is?
How many square feet?
I guess what the architect stated there.
Yeah,
Okay.
Greg, where's the file?
it's right here.
The big one.
So it's realization.
Let me see those, Matt.
I'll just take a quick look at the plan, so
no
it
problem.
doesn't seem like a renewal as much as an initial, legalization.
Yes, was
I wonder who worded this application.
Yeah, I don't think we went to this one, because it was listed as a renewal.
Legalization.
Yeah.
Yeah.
Yeah, okay. Yeah, we didn't go to this one because it was listed as a renewal.
Yeah. So what brings you here to legalize it? Did you get flagged with a violation, or
No,
are you
sir,
selling?
I just
or-
basically, I got divorced in 2014, basically, so I was actually forced by the divorce to move downstairs. So in the meantime, I rented upstairs so I could keep ownership of my house. Otherwise, I would have lost it. And I ever since been living there. And
So I'm just, normally if it's a new apartment, we try to take a look at it in a little more detail versus a renewal, which, we've already approved in the past. Would it be a hardship if we adjourn this to next month and set it down for a site visit to see?
not a problem, sir. I mean, it's up to you
know,
guys.
it's like you're not selling, it's not a contract issue or anything.
No. I live
Yeah.
there. You could come by.
I think that's our
tomorrow if
best
you like.
bet. Yeah, that's our best bet on. This is really more of a new application than a renewal. We usually see them once, and that's it. You just come back every 3 years for a renewal.
I understand.
If we
So
approve
if we see it the first time, we can look at the parking, the sizes of everything, and just
Yeah, I think show up also a diagram of the parking spaces.
yeah.
Yeah, there is something.
We weren't really
there.
so.
That's, I mean,
As long as it's not a burden to you, that would be a better way for us to really look at everything in more detail. The renewals, we don't really have to look at too hard normally because they were already looked at in the past.
not a problem, sir.
All right, so let me set this down actually for a site visit.
Actually, you need to adjourn it first and then set it down for a site visit.
Okay. So let me make a motion to adjourn this hearing to our December 11th meeting.
Okay.
Sorry for any hardship that causes you, but.
Oh, no, sir. I
Yeah,
just,
Thank you.
Great.
Thank you for your understanding. We
And
appreciate that.
I will also make a motion to set it down for a site visit on December 6th.
that was actually the first time I came here when you said that you weren't gonna pay a visit. I was like,
Yeah, because it said renewal, and
Yeah.
those are usually, we've already seen them. Maybe it wasn't me personally, but the board. So once it's approved really the first time, the renewals are administrative in nature. We just kind of sign
Yeah,
off on
I
it.
was asking that, I don't have even
Yeah.
a stove there.
All right.
I was asking her what should I do, and then she told me actually I gotta get because I haven't decided whether to install like an electrical or gas range.
Oh, you're waiting on the stove. Yeah.
No, waiting actually to find somebody that give me a really good quote because they asking for too much money, so I never rather.
Okay, so I think that's a better game plan. We'll take a quick look on December 6th, and then we'll have a better hearing on December 11th. All right? Thank you
Second.
very much. Appreciate it.
Second.
All in favor?
Aye.
Thank you. That's
Good.
it.
We'll see
see
you
on the 6th.
We'll see, and then on the 11th.
If we have to get in, which we probably do, yeah, Saturday morning, okay? And yeah, all right. Thank you.
I'm gonna be informed when you're coming, right? So I'll be home.
Well, where is this? Hollywood.
Hollywood
It's
Street.
10, 11 in the morning usually, or maybe 10:30, 11 on that Saturday morning.
Between 9:30 and 11:30, we should be over there.
It's December 6th.
On the 6th, December 6th.
December 6th?
December
Yeah.
6th, yes, sir.
Okay, thank you.
Thank you.
Marcolage, 2752 Windmill Drive. This is an application to legalize a front porch that requires a variance for a front yard setback of 24.3 feet, where 40 feet is required.
Trying to find
Kyle, why don't you just state your name for the record?
Razak Markolai.
Okay. All right, we got a nice picture right there. So I have a memo from the building inspector who came out to look at it. Steve Frietta, date October 20th, 2025. This is an application for a building permit to legalize a front porch
yeah,
that
I have it.
requires a front yard variance of 24.3 feet, where 40 feet is required. I've inspected the property and found no violations. This will require a building permit and a certificate of occupancy. I have no objections to granting the relief. So since it's already there, we have a nice picture. I don't see any major issues with this one as far as the character of the neighborhood.
Does anybody have any comments
Okay.
on this application? No. Okay.
He does.
So I will make a motion to grant the application at 2752 Windmill Drive for a variance for a front yard setback of 24.3 feet, where 40 feet is required,
For 3 years.
with the stipulation that this applies only to the requested variance and not the remainder of the property line, and that the building permit and CO are obtained. Do I have a second?
Second.
All in favor?
Aye. For
Thank
3
you.
years.
It's granted.
Thank you so much.
You're welcome.
Have a good night.
For 3 years.
Put that with this one.
Bertino?
Okay, everything all together?
I don't know where he filled
I'm
out
Mary
that
Scott,
picture.
the architect for Matt Bertino, and his parents are here. Matt's traveling.
Okay, let me just tell what this is a application to construct an addition at 3226 Mohegan Ave in the rear of an existing home that requires a variance for a rear yard setback of 25 feet where 30 feet is required. Okay.
Right. So the existing
file.
house has a bump out.
Yes.
Like a porch enclosed. What we're asking to do, it's not insulated, not heated. So we want to take that down and basically fill in going across so that we have a dining area, mudroom entry, and washer dryer. Part of it is that you enter, this property has a front yard and the backyard is actually Tamarack, which is where you can park. Mohegan, you can't. So everyone enters through this side. So that's why we wanted to make this a kind of more formal back entry. So
Are we putting a dormer on that?
It's actually, it's just
I'm looking at the
a
picture right where your hand is,
one story
in the back.
It's like a
in
portico.
the back.
Okay, I'm doing off the picture now.
Is
I
that a
got you. I
port-
see what you're talking about.
Yeah, it looks like a dormer, but it looks, maybe it's just
Yeah,
like
no,
a
I mean, this
portico.
is,
Yeah, yeah,
it's
yeah.
just
No,
when
I
you're
got you.
looking at the side of the
Okay.
roof.
I got it.
So it's basically this roof stays, but we're coming out, one story, going straight across.
Cool.
Okay. Anyone in the audience have anything on this one?
I think that lady does. That lady has something.
We're all trying to we're just trying to get home. We're just trying to get home. I have a memo from the building inspector, Steve Frayetta, October 20th. This is an application for a building permit to construct an addition on the rear of the existing home that will require a rear yard setback of 25 feet where 30 feet is required. There are existing variances for front yard and lot area. I've inspected the property on October 16th and found no violations. This will require a building permit and a certificate of occupancy. I have no objections to granting the relief.
Second.
So, any issues with the character of the neighborhood? I didn't know.
Nope, it was very nice.
So I will make a motion to grant this application for a rear yard setback of 25 feet where 30 feet is required at 3226 Mohegan Ave with the stipulation that this applies only to the requested variance and that the project be built in substantial conformity to the plans that have been submitted. Do I have a second?
Second.
All in favor?
Aye.
Aye.
It's granted.
Aye.
All right, yep. Well, we need another member, as you can see, so
Come on,
you
come
seem to be good at it. That's all you really need to know how to do is say aye or nay.
Hey, right. That's it.
You're welcome.
And have no problems with forms.
Yeah. Cano? This is an application for a special use permit for legalization of accessory apartment that requires a special permit as at 1709 Summit Street. Okay, so just state your name for the record.
Hi, Lena Cano.
Okay. So I wasn't with you guys.
I didn't see
you
any.
got inside.
No, we didn't. Oh, no,
No, we didn't go
we
inside
didn't go
this
inside for this one.
We just took a look outside.
Yeah, we pulled into the back of the property with the driveway, the long driveway in the back, yeah, or how that's situated.
So it's it's a legalization of something that was there, or is it a new
It was already there.
already there?
Here's a
Was
memo.
that a shop or something at one time? Did the guy have like the way that the garage was set and there's a fan? Did he have some type of a shop or something in the back at one time? Just,
I have
just,
no idea.
just curious. Just,
I
it's
don't
just a
know.
conversation, sorry.
Okay, so I have a memo from the building department, Steve Frayetta, October 20th. This is an application for a new special permit for an accessory apartment per 300-38 of the zoning code. I've inspected this property on October 16th and found an existing apartment to be legalized with no occupants residing at this time. The applicant has to file a building permit application and will be required to get a certificate of occupancy. I have no objections to granting the special permit. So I'm sure he explained this to you. You have to now if we approve it, get a building permit to legalize this space downstairs. It's really,
Do you understand, or do you have a question?
Yeah.
Okay, I mean, it's pretty straightforward.
Yeah.
You get down to the building department, you fill out the application, they come out, they inspect, and then they get take care of your paperwork, then you get granted. Okay.
that's what should have been done in the first place. If you build anything, you or whoever did it should
Yeah, I
get
know.
the permits, and then everything's legal. But it has been known to happen that it has to be done after the fact. So, you're not the first person, but I just wanted to make sure you knew that you have to complete that step. So I will make a motion to grant the special permit, special use permit for an accessory apartment at 1709 Summit Street with the stipulation that the applicant will pursue and receive a building permit and a certificate of occupancy. And this permit is for a period of 3 years. Do I have a second?
Second.
All in favor?
Aye.
Aye. Okay,
All right, thank you.
so this part's done.
Thank you.
Got all your paperwork in here?
Yeah, I didn't take a picture of it.
Good night.
Thank you. Carfagno, 1579 Summit Street. Sorry to keep you so long. This is an application for a special use permit for a change of owner. Let's see what we got. So, are you the new owner?
Yeah.
or-
It's my mom's house. I just bought it.
Okay. So, did we see that? Did you guys go to this?
This one we didn't have to go to.
Okay. It's basically a renewal.
Yeah, it's a renewal.
Okay. So I have a memo from Steve Frayetta, application for a new special permit for accessory apartment per 300 of the zoning code. Inspected this property on October 20th, found existing apartment to be legalized. The applicant has filed a building permit application and will be required to get a certificate of occupancy. I have no objections to granting the special permit. Any comments? Okay.
As long as I can get it, I'm
Yeah.
good.
Yeah, so, you know, once you make the sale, stop selling, I always say to people. Okay, so I will make a motion to grant the special use permit at 1579 Summit Street for an accessory apartment for a period of 3 years, subject to the applicant receiving a certificate of occupancy.
Second.
Second, all in favor?
Aye.
Okay, it's
So I
granted.
just see you in 3 years, is that it?
Yeah, you gotta
Yeah.
come back and come back again. Yeah.
All right, thank you.
That would be amazing. So we can see you in 3 years, and then we don't do anything other than, in fact, you probably don't even have to come. With the renewals, we do without you
But
even.
don't tell her that. She wants to come and visit with us. Come on.
Okay. Are we done? No, Sanchez? Sanchez.
two.
Sanchez? 2980 Curry Street. This is an application to construct a two-story addition that requires a variance for front yard setback on a corner lot of 29 feet where 40 feet is required, and a rear yard setback of 35 feet where 40 is required. Previous variance was granted.
Oh, I know. Yeah, we saw this one.
So just state your name for the record and,
Michael Picarello, MAP Architects, representing John Sanchez.
okay.
So yeah, we also represented John way back when for the first variance, because they're situated on that corner lot.
What was that for? You remember the first one?
We did some work in the rear section, which used to be a deck.
I remember that. How long ago was that?
Sorry?
How long ago was that?
That was back in 2012, a long time ago.
So do we have any kind of picture?
For some reason, I didn't
I think we,
Okay, we have.
Oh, I've
well,
got-
we
It's
got the
there.
old
Yeah.
school.
they were submitted in the.
Yeah, no, I know.
Good.
We have them.
You got them?
Fall
I've
down.
got them.
I love doing this.
It's old school.
It's good, yeah. Hey, you printed out 12 copies.
This is a new
man.
sobriety test. This is a new sobriety test. Can you full day that?
All right. Just like to take a quick look. Yeah. So, I guess they're all front yard setbacks here, even though one.
Actually,
it's a-
actually,
Yeah.
the correct nomenclature is side yard equal to a front yard.
Yeah.
You
So-
only have one front
Yeah,
yard.
we can change that.
Yeah.
Which one, and that's
That's
something we
really the issue.
probably should clarify now.
What's the front yard?
The variances that we did last time in 2012,
Yes.
do you remember whether or not you used that as the front yard, or was it the Curry Street one?
No, the dimensions would have been the
would have
same.
been the same,
But that was, the Curry Street is their front door. So,
so the Curry Street is the one that you're considering as the
Front.
front yard, and the variance that was granted prior to this in 2012 basically used the other one as a side yard.
correct.
Okay.
So that's, yeah, so,
So basically, what we're doing is we want to call it a front yard for this particular variance.
yes, that's what we had here, so.
Okay, because again, the nomenclature, you really gotta keep it
Yeah.
correct,
Consistent,
because
yeah.
in the future, when we're all gone,
It's interesting, again, not to deviate from this discussion, but different towns actually look at it differently.
Yeah.
So like in Rye, you can actually pick and choose which front is front and side. Every time you go back, you can change your mind.
no kidding.
It's very strange.
must be
yeah. I've gotten variances in the same house, both ways, because I choose that's going to be my
Wow.
front, that's going to be on my side. Yeah, it's very interesting.
And so how do the addresses work? I mean, does the address stay the same?
The dress always stays the same.
Yeah, it doesn't
If
matter.
you change the, okay.
Doesn't
Yeah,
matter.
okay,
Yeah, it's just it has to do with basically the setbacks essentially.
Yeah.
So I mean, so obviously this house is existing non-conforming, and they have essentially a very limited backyard, so and no garage. So they wanted to have a typical two-car garage. So that's what we're proposing here, and putting that on the side of the house triggers the need for a variance. There's not
Okay.
much. There aren't any other locations to put the garage. So we tried very hard to avoid a variance, but it does not seem like.
But that makes this one a side instead of so one of them, in
Yeah,
following this discussion, if we make this, call this the front,
This is gonna be the rear.
right, so this other variance
Is
is a
side,
side yard.
side
variance.
yard, side yard.
Yeah, so one of the requested variances was rear, but we're gonna call it side.
It's fine.
Right,
Yeah.
we wanna make sure.
It's
that's
going to be the
why-
last one. So
Yeah, I wanna
No more.
make sure the terminology is
yeah, no, I
correct.
get it. It's confusing. So.
It's confusing.
Yeah.
Let me
So-
just read the memo real quick. Steve Frayetta, October 20th, application for a building permit to construct a two-story addition that is requesting variances for front yards west setback on a corner lot of 29 feet where 40 feet is required, and a rear yard setback of 35 feet where 40 feet is required per the zoning code. Previous variances for the property have been granted. I inspected the property on October 16th and found a shed that will need to be legalized. This will require a building permit and certificate of occupancy. As for the addition, I have no objections for granting the relief requested.
Okay.
I forgot about the shed. So, do you know about the shed?
I knew. Yeah, we found out about it sort of after the fact as far as the application goes. So we'll have to have that legalized. I'll speak to Stephen about
Yeah,
basically.
I mean, basically, he indicated we just needed a building permit.
You can probably amend your building permit or whatever. It
It
doesn't
doesn't
require a
anything,
variance. Yeah.
Yep, we definitely do that.
Okay, so I will make a motion to grant the application at 2980 Curry Street for a front yard setback of 29 feet where 40 feet is required, and a side yard setback of 35 feet where 40 feet is required. The stipulation that this applies only to the requested variance, not the remainder of the property line, and the addition be built in substantial conformance to the plan submitted. Do I have a second?
Second.
All in favor?
Aye.
Thank you very much.
You're
Appreciate
welcome. So,
Don't move.
Nazreen, did you hear the differences on that, or we'll get it in the
She's indifferent to that.
the minutes? Okay. Nassif, you're on Nassif too?
Correct.
Okay. This is 809 Lock Lane, application to construct a detached garage that requires a variance for side yard setback of 5 feet where 30 feet is required.
Sanchez.
Sanchez.
Put your map back in there, take your notes out, put your map back in there, plans, and I'll give you the next one.
Sorry.
There you go. One of these days you'll be all right. You know? Here's your little therapy going on.
So, sorry for the delay. You can restate your name for the record.
Sure. Michael Picarello, MAC Architects.
Like he might have
Representing
forgotten.
Peter
Like he might have forgotten it in
Minute-
5
well,
minutes,
we
you
gave
know.
a minute, so-
Yeah.
It's been a while. I haven't been here in a while.
I'd
so-
be a little nervous, you know, if
It's
he
okay.
forgot his name.
Okay, so we're looking at a large 4-acre lot and a detached garage.
Correct. So the property is obviously large. The location of the house and the existing driveway, if you guys were out there, you can see the elevation of the house and the driveway coming in. There's no other location for a garage because of the way the property falls off in the back and the way that the steepness of the property comes down to the house. In fact, it's a difficult turnaround. So the reason for the variance for the garage is because of the turnaround space. There physically is not enough room to to pull in and then pull a car out unless we push the detached garage closer than the setback would require us to. So that's why we're seeking a variance for that side yard setback. We tried to figure out different ways. We've actually reduced it down. It was up to a larger garage project. We actually reduced it so that we could squish it up as tight as we could to the property and get enough room to actually physically pull out of the garage and pull it into the drive. So we can't move it down toward the slope because it falls off pretty quickly, and then we can't move it up the slope because it goes up pretty steep. So the good part about where the garage location is in comparison to the other houses, aside from the fact that essentially it's in the woods, is that the neighboring house is up the hill and away from the garage, so they won't really have a direct line of sight. And Peter has actually spoken to all the neighbors, and they're all in favor of it. So this.
You're going to do any screening, or proposing any screening for
It's
the neighbors that can see?
Yes, I mean, certainly, they were going to do some screening behind the garage, essentially on the neighbor side, so we can definitely make that part of a condition if the board would like that.
So before I read the memos, anyone in the audience for this application? I should have asked that a few times ago, but
That guy right there.
we're running out of applications.
That guy's objecting. He's objecting to the
We're running out of applications, and we have people sitting there. So anyway, I'll read the memo from Steve Frayetta, October 20th. This is an application for a building permit to construct a detached garage with a side yard variance of 5 feet. So it should say side yard setback of 5 feet where 30 feet is required. Inspected the property, found no violations, will require a building permit, certificate of occupancy, no objections. So with regard to screening, I guess we could discuss that. I kind of got the sense it was in the woods also, so I don't
Got a few
know.
there. It's definitely, you can see it from
Can you?
the other people's house.
Would they get like enough sun and everything to?
Depends on what you plant there.
Yeah.
You could put low light shrubs in there, anything to kind of just make it blend a little bit more. Really, it's not necessary.
I mean, we don't
it's,
have.
it's not. It's not.
He
It's
did
not
state
crucial.
that the neighbors.
Everybody likes the property. It's a
the
beautiful piece of property.
The neighbors were in favor of the project, which is maybe at least not opposed because they're not here. We don't have any memos.
Start screening and you'll be on the other
Yeah.
person's property.
Yeah, it may make it worse. Like the person
you're
might.
right. You're right.
you know,
You're right.
if
You're right.
they- if they want
when I think
screening,
about it,
yeah,
when I
yeah.
realized what you were saying, as I said it, but no big deal.
So I will make a motion to grant this application to construct a detached garage for a variance of a side yard setback of 5 feet where 30 feet is required at 809 Lock Lane, with the stipulation that this applies only to the requested variance and not the remainder of the property line, and that the garage be built in substantial conformance to the plan submitted. Do I have a second?
Second.
All in favor?
Aye.
Okay.
Thank you very much.
Have a good day.
Take care.
When you get a chance, kick my pencil. Sure. Thank you, lad. I can't
So,
work without my
are you here for an item on the agenda? I'm not. Just observing? That's good.
Man, oh
Okay.
man, that doesn't happen
Got
often.
me nervous that
Wow.
I forgot something.
Are you having trouble sleeping? Teasing. Cool. Do we have to
Very
sign
good.
anything that you were here, you know, certified that you showed up?
We
Honest
we
system,
haven't
all right,
finished
I like
yet.
that.
No, do we have any renewals?
No,
Nope, everything's
good.
Oh, I'm sorry,
Okay,
Tommy.
so this concludes our meeting for the Yorktown Zoning Board of Appeals on October 23rd, 2025. Good night, and have a happy Thanksgiving.